SJC-10279, Johnstone versus a Commonwealth.
Ms. Smiley, good morning.
Madam Chief Justice, and may it please the Court. This Court has recognized last month that the Commonwealth may rely on expert opinion from a source other than the qualified examiners. This Court has said, and the legislature has recognized, that the prediction of sexual dangerousness requires expert, not lay evaluation. Just as this Court has recognized it, so too has the legislature by the creation of two sources of expert opinion. First, the qualified examiners, and second, the Community Access Board.
Did either side ask, what's his name, Dr., the CAB person?
Dr. Bell?
Bell, right, thank you. Did either side ask him his opinion?
The way the testimony came in is Dr. Bell was asked the board's opinion, which he said was unanimous, and he said, and I quote, "We, all five of us, feel that the petitioner remains sexually dangerous."
Are all five experts?
All five of us, meaning all five members of the Community Access Board.
I understand that. Are all five, is it the Commonwealth's position that all five are experts?
The board as a whole is an expert?
No. You said the answer was all of us. Are all five individuals experts?
At least the three psychologist members of the board were experts. The credentials of the other members of the board were not before the Court, but I will tell the Court this, is if all three of the psychologist members of the board had opined not sexually dangerous, the Commonwealth would then have told the Court we would not make a prima facie case and we would not have proceeded.
So is it your position that if let's pause it for a minute, there's a unanimous or a 4-to-1 board decision.
Which way?
Saying that the petitioner is sexually dangerous. Is whoever wrote that CAB report, the deputy superintendent of Bridgewater, let's just say he was the author or she was the author, would you consider that report to be an expert? That would satisfy the need for expert evidence?
The expert report could still be expert opinion, but depending on the qualifications of the deputy superintendent, it would depend on whether he qualified individually as an expert. But in this case, because this Court...
Okay, I know this case. I'm just trying to figure out if you are saying that the CAB report as the CAB report inherently is an expert report.
Yes. It has expert weight.
Is it your position that even when both qualified examiners say a person is not sexually dangerous, that they can still be found to be sexually dangerous?
Yes, provided that the Commonwealth provides and produces expert testimony, because this Court is required to be expert testimony at the trial.
What's the purpose of having qualified examiners then?
The purpose of the qualified examiners is to provide one source of expert opinion to the fact finder, but not the exclusive source, as this Court has recognized as recently as last month in the Cowan case, where the Court said that the Commonwealth in an initial commitment case was entitled to call and did properly
yes, but
call.
that case
But in
did
that
have
case,
one.
there was one, wasn't there?
One qualified examiner.
That's true. But there's never been a requirement by this Court that the expert opinion come exclusively from a qualified examiner. In Poissant, this Court in footnote 6, a footnote that has launched 1,000 questions at the trial level, said we leave open the question of whether we're both qualified examiners in an initial commitment case opine not sexually dangerous.
Ms.
Whether
Smiley,
that, I'm sorry.
finish your sentence, I'm sorry.
Whether that would require a finding of not a dismissal of the Commonwealth's petition.
No, I know we know what footnote 6 says. Could I just ask you this? First, in order to become a qualified examiner, you have to have 2 years of experience with diagnosis or treatment of sexually aggressive offenders, correct?
That's correct.
With respect to the psychologists, they were?
Dr. Bell in this case had been previously designated as a
No,
qualified examiner.
I'm sorry, I'm talking about the CAB, the people who constitute the CAB board.
The 3 CAB psychologists have been designated, who were on this panel, this reviewing board, had been designated as qualified examiners.
What do we do in cases where they have not been?
It would depend. It would be a question of whether they qualify as experts.
No, well, my question is the following. As I understood, that the Commonwealth really was doing 2 things here, saying, one, we've got Bell, who happens to be a QE, correct?
Correct?
But then we have CAB's view qua CAB.
Correct.
But if CAB, if the people who constitute CAB do not have the expertise, it just so happens, you know, whether it's the deputy director, Bridgewater, or even a psychologist who hasn't had the 2 years experience with diagnosis or treatment of sexually aggressive defenders. As I understood your brief, you were saying you can, just because you're sitting as CAB, quote, quickly acquire. Isn't that what you said?
Our argument is that you can become an expert in this field without having reached the formal designation of a qualified examiner. And some members of the Community Access Board who are psychologists...
That may be the case, but that means that CAB, qua CAB, is not the expert. There may be an expert. If we agree with you that even in the face of 2 negative QE reports that the Commonwealth can introduce in Section 9 other expertise, it can't be CAB expertise, because that would require, in each case, looking to see whether a majority of the CAB board were in fact QEs, as they happen to be in this case. What you might be able to do is to introduce the expertise of an expert who a judge determines to be an expert sufficient to be able to opine on the predictive behavior of somebody who's been convicted of a sex offense, correct?
In part. The CAB board, the CAB is important, and the reason for the placement, I would suggest, of non-psychologists but Department of Correction employees is a recognition by the legislature, and one made by this court, that the observation of confined individuals will reveal dangerous tendencies. So the so-called non-psychologist
But it can't be
members-
expertise. You've already said that we need to have, as we have said, that you need expert opinion.
Absolutely.
But those are not experts.
Depending on their training and experience, the non-psychologist members could be. I have told the court that in
How
this...
how could they be?
You can become an expert by your training and experience. For example, Robert Jackson served as a justice of the United States Supreme Court until the 1950s, but he never graduated from law school. He read the law. People can become experts in a number of fields.
Excuse me, miss, with all due respect, we have for centuries had people who didn't have to go to a law school. It's well recognized that a law degree is not the only way to obtain expertise. There's nothing that we have before us that says that simply sitting on the CAB board makes you an expert on being able to predict sexually dangerous behavior.
Madam Chief Justice, I was not suggesting that that would be the only source of their training. I'm saying people can become experts without having a PhD in psychology.
Of course, yes. But
I'm
that's,
not making that argument about these 2 particular CAB
No, but that's
members.
precisely my point. There might be somebody that the Commonwealth individually wants to have examined in a voir dire, and a judge might conclude that that individual is an expert. I agree with you. And the sources of expertise might or might not include formal training, and they will be subject to cross-examination. That's an individual expert witness determination. That is not CAB.
The legislature charged the Community Access Board with evaluating current sexual dangerousness. Twice, both in the defining section for the Community Access Board in Section 1 and repeated it again in Section 6A. The legislature clearly intends the Community Access Board to have an expert presence. We know this because they required at least some of the members to be psychologists or
they may
psychiatrists.
be required to have some presence. I'm not sure that it may be required to have some presence, but it doesn't necessarily make any members experts for purposes of satisfying the necessity of having expert testimony. We've got a directed verdict in this case, correct?
Correct.
I don't know what the function is in the same way that your response to Justice Ireland was, well, why do you need two, what's the purpose of two QEs? And your answer was a source of expertise. In
That's
other words,
correct.
A source of expertise. There's nothing to say that I can see that CAB is a source of expertise.
When we look at their statutory mandate, their mandate is to conduct an annual review
Correct.
of sexual dangerousness.
Yeah.
The question of sexual dangerousness is one that in this court, which has said and indicated for decades, requires review of the mental condition. It requires expert, not lay evaluation. The legislature is presumed to understand the state of the law when it enacts legislation.
Ms. Murray, in fairness, it wasn't called CAB, but the same, isn't it so that the same requirement of having an annual review of sexual dangerousness existed under the RIRB, which preceded the Bruno case?
The RIRB was created in the mid-1980s. It did have as one of its functions to contain in its reports a statement as to whether the person indicated remains sexually dangerous. When the legislature abandoned the RIRB and enacted the CAB, it gave the CAB a separate and distinct function of conducting this annual review and articulating it in a separate report.
There might well be reasons why the legislature might want that. For example, the legislature might want to have absolutely non-expert people come in and say, I think you're holding people, we think you're holding people who are not sexually dangerous. I can think of lots of reasons why a legislature might want to have that, not just relying on experts. There are all kinds of things that one can do with that data. Certainly if I were a legislature, I might want that.
And the legislature provided for that by requiring that the superintendent of the facility or his designee be permitted to come in and testify as to the department's position, the Department of Corrections position, on a particular, for the disposition of the petition.
I understand that, but that doesn't turn him into an expert. I mean, you then have a trial that based on expert opinion determines whether or not somebody can remain incarcerated, a very significant liberty deprivation.
Absolutely.
And you need experts, whether you're talking about Hendricks or whether you're talking about qualified experts, and then the legislature, I think, made not terribly onerous, but certainly pointed requirements as to what would constitute expertise, namely only 2 years, but 2 years with specific experience in the diagnosis or treatment of sexually aggressive offenders.
And the Commonwealth offered that proof through the testimony of Dr. Bell.
If the two qualified examiners, as in this case, had reported that Mr. Johnstone was not sexually dangerous, and if CAB unanimously had reported that he was not sexually dangerous, could the Commonwealth have proceeded with yet another expert?
There's nothing in the law that precludes it at this point, but I will tell you that I've been with the department and working on these cases for nigh on 11 years, and our practice has been, for the 7.5 years that I've been running these cases, that where the CAB psychologists and both qualified examiners opine not sexually dangerous, we will report to the court that the Commonwealth cannot make a prima facie case. The court, of course, still has to act on the petition because nobody other than the court has the authority to authorize the release. You're committed until released by the court pursuant to the provisions of Section 9. And in the 7.5 years approximately that I've been supervising counsel for the department on these cases, we've had that instance 13 times by my count. So
Out of how many?
I haven't counted the total number of cases we've tried. I'm sorry, but I
mean,
personally have tried well over 60 of these cases.
Okay. Could I just add one modification of Justice Spina's question? If both QE say not sexually dangerous and there's a split decision in CAB, what is the department's position?
If one of the CAB psychologists who would be deemed an expert opines sexually dangerous, we proceed to trial and let the jury resolve the conflict in the expert opinion. That's actually going on. One of those matters is going on this week. One CAB member is testifying sexually dangerous. Another who authored the minority report was called by the petitioner to testify as to the, he authored the majority report, and he was called to testify on behalf of the petitioner.
And the QEs reported not, that the person was not sexually dangerous?
Yes.
Do you ever, I mean, do you see it as your function to accept in the case where you have both QEs and a unanimous CAB report saying someone's not sexually dangerous? You see it that the department's function is to resist the release of any?
Well, it's not the
person?
department's position. We're representing the Commonwealth at the request of the Attorney General's office. But where there's a split in expert opinion, we believe that it is for the fact finder, the judge or the jury, to resolve that conflict.
Do you happen to know, Ms. Miley, and it may not be relevant, but perhaps it is, what the cost of obtaining 2 QE reports is to the Commonwealth?
The Commonwealth, the Department of Correction contracts with the vendor. It's approximately $2,200 for the evaluation that we pay to, that the department pays to the vendor for the evaluation. The
By both QEs?
Yes.
And
And
does that include their testimony at trial?
No, there's a separate contract rate for either a half day or a whole day of testimony. I don't have the numbers firmly in head, but I'd be happy to send a supplemental letter to the court. But
Do you
it's
have
around.
any idea if you had the 2 qualified experts, such as in this case, who prepared reports and then testified, presumably that this man was not sexually dangerous, do you happen to know what the total cost to the citizens would be?
The reports would have been, again, around in the $2,000 to $2,500 range, and then the cost would be for the testimony. I don't happen to know if they were there full day or half day, because that can include some waiting time if they're expecting to come in as soon as the jury's impaneled and the openings have been made. But it's around, it's between $1,000 and $1,500.
Per QE? Or?
Depending on their full day or half day. I think it's less than $1,000 if they're there for a half day, and somewhat more than $1,000 for the contract rate.
For each doctor?
That's correct.
And do you know how many, you have a contract, I mean, how many QEs are retained each year?
There's a pool of qualified examiners currently in the range doing Section 9 evaluations, around 17 to 20 of the qualified examiners, some who also sit as members of the board. Obviously, they wouldn't be on the board in the same case where they're doing a qualified examiner evaluation.
But they can sit on the board in some cases?
Some
and-
of the members are appointed both as CAB members and qualified examiners. Dr. Bell, for example, in this case.
Thank you, Ms. Miley.
May I answer? Is it your position that if there's a QE report that says the man is SDP, is that sufficient to get to the jury, in your opinion?
Provided that we bring the author in, the qualified examiner in to testify, because this court has required that there be in-person testimony. But yes, any expert opinion, we need some expert opinion to proceed to the jury, expert testimony in the courtroom.
And the report itself would be sufficient, in your opinion?
Well, this court has required that it be a live testimony,
Well,
I believe.
So, with a person, a member of the board, a qualified member of the board, testifying.
Yes.
Would it, if it was not a QE member of the board, but a member of the board, and the board had opined the person was a sexually dangerous person, would that satisfy, in your view, the in-person testimony, because he or she is testifying about what the report concluded?
Provided that individual's independently an expert, certainly. I would not.
Okay,
we
well,
would
that
not,
was the question. You would say that person had to be an expert himself or herself.
we would proceed in that way because we think it's the prudent course of behavior, given what this court has said about in-person testimony, live testimony, and certainly in Bradway, the appeals court required that where a report's made admissible by statute, you produce the author. The practice is for a psychologist to author the report if any CAB psychologist is in the majority or minority position for a report to be authored.
Just one other question. It can be any as long as there's a psychologist. It doesn't have to be a psychologist, or my question is, does it or doesn't it have to be a psychologist who would independently qualify as a QE as defined by the statute?
Well, that's the position we've taken
Okay.
to date in this case. Certainly, there could be another member who perhaps had long experience evaluating sex offenders, who doesn't have a PhD, doesn't have a doctorate in psychology. But that's not the argument we're making here, because this case doesn't
Because
present
Dr.
those
Bell has
facts.
those.
Dr. Bell has those credentials, and there was no challenge to his credentials below. And there's been no claim by the petitioner that he did not understand that Dr. Bell was offering his own opinion. In fact, he clearly told the trial judge that Dr. Bell, it's Dr. Bell's opinion that the petitioner remains sexually dangerous. He told the court that during the oral argument on the motion for directed verdict. So
Did the Commonwealth give notice that Dr. Bell was testifying as an expert witness?
Well, we provided the CAB report, and we provided Dr. Bell's CV, and it's quite commonly understood that he's testifying in that capacity.
In what capacity? As an
Expert.
As an
absolutely.
individual expert?
Absolutely, and I would I suggest, most respectfully, that we consider the petitioner's opening statement, where he invited the jury to consider Dr. Bell's in the CAB's methodology with the methodology of the 4 witnesses he'd be offering. Clearly, that indicates that he understood Dr. Bell would be testifying as an expert.
Well, the other side argues in its brief, I think, unless I'm remembering it correctly, that he wasn't called as an expert, and he didn't have an opportunity to cross-examine him as an expert, and I didn't understand that.
Justice Cowan, I think that the appeals court made that statement, but I
Who's
don't
the appeals
understand the
court?
petitioner's counsel to be making that, even in his brief to this court. And certainly there's
That's right,
no...
it was in the appeals court, and I didn't understand that.
I didn't
we
either.
can ask Mr. Fox that. Thank you, Ms. Smiley. Mr. Fox?
May it please the court, my name is Robert Fox. I represent the petitioner, George Johnstone. Long before there was a community access board and long before there was the restrictive integration review board, there had always been a requirement under Chapter 123A that there be 2 medical professionals. First, they had to be psychiatrists, then later on, they could be psychiatrists or psychologists that would have to make a determination about the dangerousness of a person in the treatment center. Eventually, this became codified as the position of qualified examiner, requiring the extra experience of 2 years of treating and diagnosing sexually aggressive persons.
Did you understand that Dr. Bell was testifying as an expert? Or whoever tried this below on your side?
I tried it below. I think sometimes we use the term expert, and this court, and I think the appeals court has done on occasion, not necessarily in a technical sense, but in a generic sense that someone has some medical
Well,
experience.
did you understand him to be testifying individually, whatever his qualifications, or or did you understand him to be presenting the CAB opinion?
I presented him, I understood him as presenting only the CAB opinion.
Did you want to cross-examine him as an individual expert?
No.
Could you have? He obviously
I
he
suppose I
obviously
could
was
have.
credentialed to be an
I
expert.
did question his credentials at the
But I
trial.
mean, you could have cross-examined him as an expert witness had you chosen.
I didn't see the point of it because he was testifying as part of the CAB.
Well, no, but if you thought you could get some helpful information from him, testimony
I
from him.
suppose I could have.
Well, except in this case, Dr. Bell had signed the CAB report, so whether or not we conclude that the CAB report, qua report, is, quote, expert sufficient to satisfy any, to meet a prima facie proof that the Commonwealth has, you knew that he had signed it, so that if you were beginning to ask Dr. Bell, what's your view individually, never mind CAB, you pretty well knew what he was going to say, right?
Right. And throughout his testimony, he constantly reiterates that it's the CAB's opinion.
Correct.
That's
So
going on.
what was your position at trial? What were you trying to do with the CAB report?
With the CAB report, I was just trying to show that it was did not have the same expertise behind it as the qualified examiner's reports. The Dr.
So you
Bell
were
does
not,
have the
you were
same-
not challenging its admissibility?
It's by statute it's specifically admissible.
No.
Did you file a motion to dismiss the complaint or the petition, whatever it's called, on the grounds that there was, that the Commonwealth could not, the evidence in its light most favorable to the Commonwealth, it could not possibly prove this case because the two QEs had indicated that Mr. Johnstone was not a sexually dangerous person and just cut off the whole prosecution right at the knees?
I did not.
Doesn't that presume that there's some evidence that the Commonwealth could rely upon to establish its prima facie case?
In looking at Section 9, it would seem that even if the CAB had filed the petition on the grounds that they thought he was not dangerous, still qualified examiners have to be appointed, have to examine and diagnose the petitioner, and it appears that a hearing is required. I took that to mean there has to be a trial, particularly where jury trial is requested by one or both of the parties, as it was in this case.
Just to follow up on that, though, whether or not you filed a motion, your position is that with the two qualified examiners saying that your client was not sexually dangerous, that means as a matter of law that the Commonwealth cannot succeed? Is that your position?
That is petitioner's position, yes.
And is that based on an analysis of the statutory language?
Yes.
And get
Yes.
me through, how do you get there?
Okay, I do talk about it in my brief, but I think if the fact that there is a body of qualified examiners and that they have the more specific duty of diagnosing, examining and diagnosing the petitioner as opposed to just a review, it shows the importance that the
It's the
legislature...
examination and discharge, that's what
Yes.
you're relying on? That's the language in the
That's
statutory language?
language, and it's certainly not clear, but I think there's enough there. The requirements of the two medical people examining the petitioner has possibly increased over the years with requirements of specialized expertise that's not required by the CAB, and where the requirements of the CAB or its predecessor have actually decreased. The Restrictive Integration Review Board was required not only to evaluate but to examine the petitioners, and those requirements were deleted when the CAB was formed. Now they just have to conduct an annual review.
Well, do you know what happened under the predecessor statute when the two physicians reported that a defendant was not sexually dangerous?
I do not.
Okay.
No, I do not.
I take it with this, I take it that part of the complexity of the statute is the third sentence that says the Department of Correction may file a petition at any time if it believes a person is no longer a sexually dangerous person, which essentially buttresses Ms. Mully's point, is that even if the department concludes, as a department could in the face of two qualified expert reports saying not sexually dangerous, that nevertheless a petition would have to be filed.
Not only that, and qualified examiners would have to be appointed, and I think it would be their...
Well, I'm assuming in this case that somebody else has. I see.
No, but if
The filing of the petition. If CAB, for example, determined unanimously that, and the department wanted to proceed to say release this person, it would still have to appoint two qualified examiners.
Right, and go through a hearing.
Well, why do you have to go through a hearing? I mean, you have to pay these QEs to get up and testify that he's not sexually dangerous. Everybody agrees he's not sexually dangerous. You have to. I mean,
I believe in that case,
on what basis could a judge conclude otherwise?
I believe in that case, no one would request a jury trial, and it could be a fairly brief hearing.
It doesn't make any sense. I mean, could a judge conclude otherwise?
No, a judge could not conclude otherwise, but it could be a fairly brief hearing in that type of situation, as opposed to this case where...
I would think it could be disposed of by motion, a summary judgment or something, some equivalent.
It's possible. I did not read the statute that way, and I could have been in error.
Oh, the statute keeps talking about a hearing.
Right.
I think that that is consistent with a non-evidentiary hearing, and so
Yeah.
if you file a motion to dismiss or a motion for summary judgment, you don't have, you could have a hearing, at least without the question being presented. It doesn't say evidentiary hearing, correct?
No, I think it says also if a jury trial is demanded, it shall proceed according to the practice of trial in civil cases.
Yes, but I take it,
You don't get a jury trial if there's a motion to dismiss, which
Right.
inures to a respondent's benefit. The respondent, I doubt, is going to oppose it. If the motion to dismiss is allowed or the motion for summary judgment is allowed, then you don't get to the jury trial. It's only when there's a disputed issue of fact that you then get to the jury trial, correct?
It could very well be that should be what is done.
Mr.
I do
Fox?
not.
What, assume for the minute that the court doesn't agree that the statute prohibits the Commonwealth from proceeding very far if the two QEs opine the person isn't a sexually dangerous person. Is it your position that, yes, they could call an expert, but in this case, the CAB doesn't supply the necessary expertise? Is that your position?
Yes.
The CAB qua CAB doesn't supply the necessary.
You're saying if the court were to hold that the QE's non-dangerous report would not be determinative?
Correct.
Yeah. Okay.
Yeah.
In that case, I believe the government would be free to call other experts. The decision in Cowan's last month certainly indicates that, at least in the
Are
section
you
Well, but
aware
it's
that
looking
there's...
at different language.
Yeah. Look, it's-
14 situation. But in the practice of Section 9s, there's no specific language allowing independent examiners for the petitioner, but those are routinely allowed.
Then you agree with the Commonwealth that the purpose of the qualified examiners is only to, they're one source of expertise, but the Commonwealth can call other witnesses to offer expertise that says that a person is sexually dangerous.
They are one source, but at least to proceed to the trier of fact, a necessary source.
So in this case, if the two QEs, as they did, report that Mr. Johnstone was not sexually dangerous, and if in this case the board had unanimously voted that Mr. Johnstone was not sexually dangerous, I take it you would concede that the Commonwealth could nevertheless proceed if it could produce an expert, a qualified expert, who was willing and prepared to testify that the defendant was sexually dangerous.
No.
If both the QEs and the CAB had said not dangerous, I don't think
Okay,
I
all
would
right.
say they couldn't.
Okay.
But in the case where there is a tribal issue for the jury or judge, I think they would be allowed to bolster their case by bringing in independent expert.
If it is your
testimony.
position that CAB is not an expert, why do you think there's a triable issue if you have two experts saying he's not sexually dangerous?
I think I've misled, because the question that started here was, if we don't find the two, if we don't agree with you that the two QEs are a necessary condition to proceed, I mean, if they're both against you, you would say that's the end of the story, right?
Correct.
Yeah, so it's not, I was asking you to respond if we didn't agree
Right.
with that, so I don't want to put words in your mouth.
Could you repeat the question?
No, it's...
Okay. And
But in this case,
Clarify. Go ahead.
go ahead.
Well, just clarify. I need to know what your position is. What about the situation where two qualified examiners say the person is not sexually dangerous? Can the Commonwealth proceed?
no. I believe that would be the end of the matter.
And you say that they really should not have been allowed to proceed in this case.
Correct.
That's your position?
And maybe it should have been raised earlier, but I think it could be raised in a motion for directed verdict.
And I take it it has nothing to do with how CAB voted. It's because, in your view, the two qualified examiners reported that he was not sexually dangerous End of case.
Right, I think that's the legislative intent. I think the bright line of that would make the handling of future cases a lot easier rather than both sides scrounging for independent witnesses at possible expense. It would create a bright line that would indicate and conform with the legislative intent that the case should not proceed any further.
And your position is the same, even if CAB has said that it believes the petitioner is sexually dangerous?
Yes, even if it were unanimous. As the appeals court indicated, and I have argued, the CAB is not a source of expert evidence. I don't think the fact that Dr. Bell or the other medical experts on the CAB were qualified examiners changes that in any way. And I don't think Dr. Bell would be able to testify to his own opinion in that situation. Normally, if an individual expert is going to testify, make an opinion, then he would normally interview the petitioner in isolation. Basically, here you had the CAB interviewing him, the different considerations, whether the petitioner would want to speak with the CAB
Well,
versus...
did you get notice that he was testifying as an expert? The Commonwealth says it's assumed that he is but
No, I got notice that he was testifying as a CAB member, and I got his curriculum vitae, which shows very little expertise in it, as I explain in my brief. There is very little indication that he had the experience. He didn't have any research. He had never testified as a qualified examiner, I don't believe, and had written one qualified examiner report. And as my time is up, unless there are more questions, I'll rest on my brief as to the remaining issues.
Thank you,
Thank
Mr.
you.
Fox.